and Forensic Evidence, the Bleeding Edge of Crawford. My name is Charlie Whitman, and I am an Associate Attorney Advisor at AEquitas, the Prosecutor's Resource on Violence Against Women, and I will be moderating today's webinar. This webinar will provide a review of the relevant case law and will explore how trial prosecutors can present a case involving forensic testing that involves a multitude of technicians and experts. It will also address Williams' impact on cold cases in which original experts who performed autopsies and other forensic examinations and testing are no longer available for trial. This webinar will provide practical suggestions to trial prosecutors who must balance limited resources against the need to secure convictions that will withstand confrontation challenges on appeal. Before we begin the substantive portion of our program, I'll provide a brief overview of our iLink webinar service. For the best use of iLink, I strongly recommend using our conference call line 530-881-1212, passcode 202-731-738, and that you call in from a landline. That information is also available in the upper left-hand portion of your screen. If you're using a mobile phone, please do not use the speaker option, but listen with an earpiece if necessary. All call-in participants have been automatically muted for the webinar. You can also listen to today's webinar using the Internet audio. To connect, please click the Connect button on the start screen of today's iLink session. If you use this audio option, please do not also call into the webinar. Only do so if you experience difficulty with your Internet audio. And if you drop out of the call, please call back in, or if you lose your Internet audio, please call into the call line. Again, that number is in the upper left-hand portion of your screen. If you experience technical issues, please use the iLink hand raise indicator, which is located in the toolbar in the top left-hand portion of your screen above the presenter's photo and to the right of the conference call number. Or you can contact iLink directly at 1-800-799-4510. Throughout today's webinar, we encourage you to post comments or questions via private chat to me, Charlie Whitman, throughout the presentation. I will share questions anonymously so that they can be addressed during today's webinar. Today's webinar is hosted by AEquitas, the Prosecutor's Resource on Violence Against Women, through funding from the United States Department of Justice, Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and the presenter's biography, will be emailed to you following today's presentation. In addition, today's webinar is being recorded for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conducts legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. Today's presenter is Teresa Garvey, Attorney Advisor at AEquitas. Prior to joining AEquitas, Terry worked for 22 years as an assistant prosecutor in Camden County, New Jersey. For 9 years, she was assigned to the Domestic Violence Unit, and for 5 of those years served as Deputy Section Chief of that unit. Ms. Garvey worked closely with the Victim Witness Advocacy Unit to provide education to the public and to community leaders who come into contact with domestic violence victims. Her jury trial experience includes the prosecution of domestic violence crimes, sexual assault, and other violent crimes, drug offenses, property crime, hate crime, and official misconduct. Ms. Garvey also has extensive appellate experience and has briefed and argued numerous cases in the appellate courts in New Jersey. Terry's full biography will be emailed to you following this webinar, along with a PDF version of today's presentation. I'd now like to turn the floor over to Terry for the substantive portion of today's presentation.
Thank you, Charlie, for the nice introduction, and good afternoon, everyone. Good morning to those on the West Coast. Whether you are in the afternoon or morning, hopefully everyone will be fully caffeinated and alert for what promises to be a scintillating discussion of Crawford and the Sixth Amendment Confrontation Clause issues, especially as they pertain to forensic evidence. And I always feel a little bit apologetic having to talk about something like this. Nobody except a true appellate geek gets really excited about these issues. They're very, very esoteric. They're very hair-splitting. They can be very hair-pulling out if you have to deal with them as a prosecutor. But the fact is, we do have to deal with them as prosecutors. You don't want to go to all the trouble of convicting your defendant and then only to have it kicked back by either your appellate court or some higher court for confrontation violations. So it's something that we have to deal with. We have to be creative in dealing with it, and we have a lot of obstacles when we're dealing with this particular issue. Obstacles that have evolved out of probably the advances in scientific testimony and evidence that was in no way foreseen by the founding fathers and mothers. So that's kind of why we have wound up in this situation. And just to get our heads in the right space and sort of get oriented thinking about this issue, we're going to do kind of a quick review of where Crawford came from and how it changed things. So we're just going to start off with that. We're not going to spend a whole lot of time on it. Of course, Crawford arises out of the Confrontation Clause, which is part of the Sixth Amendment, which states that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. It came out of historical times. There were some famous cases where people were, I believe Sir Walter Raleigh is the most famous one that's cited, convicted on the basis of evidence that was given by people who he was never confronted with at trial. So before Crawford, what's interesting is that people who went to law school when I did, we didn't even think about the Confrontation Clause. It was sort of not on the radar. To the extent that there were any concerns involving confrontation, it really had to do with hearsay issues. Because before Crawford happened, that's what the focus was on, and they were almost coterminous. They were almost exactly the same. If something was admissible under the hearsay rule, 9 times out of 10 it was going to satisfy the Confrontation Clause. So I sometimes have younger prosecutors, which is a large body of the prosecution compared to me, come up to me and say, well, we knew all that stuff. We learned it in law school. But I, at least, didn't really have to think about it at all until very late in my career. And frankly, it wasn't being raised all that often even after Crawford. So we have recanting victims, of course, when I started off doing domestic violence cases. That's been around forever. But basically, if we could make the statements that those witnesses gave out of court admissible under some hearsay exception, typically excited utterances, statements of then existing physical or mental conditions, contemporaneous observations, those kinds of things, generally speaking, you were golden. Your evidence would come in, your conviction would be upheld on appeal, and that standard pretty much was articulated in the case of Ohio versus Roberts, which stated that in order to satisfy the Confrontation Clause, a hearsay statement, an out-of-court statement by a witness, would be admissible, provided that the prosecutor or the state could show that the statement fit under a firmly rooted hearsay exception, or in other words, not one created later by the legislature or a later court-created exception, or if the statement had other circumstantial particularized guarantees of trustworthiness. And the focus, therefore, under Ohio v. Roberts was that the reliability of the statement. That's what they reasoned the Confrontation Clause was intended to protect, was to make sure that you weren't getting unreliable evidence. Of course, then Crawford came along. Life as we knew it ended. The world tilted on its axis, and everything kind of turned upside down. The court in Crawford, which was a 2004 decision, overruled Ohio v. Roberts. And just a real quick summary of the case. Crawford involved a bar fight, a stabbing that happened at a bar. The victim was another male patron, apparently, another guy at the scene. Crawford's wife happened to be a witness to the stabbing. So she was questioned separately from her husband at the police station. He was claiming self-defense. The statement she gave to the police, however, was inconsistent with his statement. Basically, it was inculpatory. When the case went to trial, she asserted the spousal privilege. And at that point, the court analyzed the circumstances under which she gave her statement, and the state courts all concluded that it was a reliable statement. She wasn't being accused of anything. There was no reason for her to lie, to inculpate her husband falsely, and therefore they ruled that it would be admissible and affirmed this conviction. So it gets to the Supreme Court, and they said, no, we aren't going to do that anymore. They go back. Justice Scalia wrote the majority opinion. He's very passionate about this. He looked back to the founding, what was considered acceptable evidence at the time of the founding of the country and the writing of the Constitution, and said that admissibility does not depend on whether the statement is deemed by the court to be reliable enough, but rather on whether a hearsay statement is considered testimonial or non-testimonial. Now, Crawford didn't say explicitly what happens in terms of non-testimonial hearsay, but in terms of testimonial hearsay, the court said that that would be admissible and not prohibited by the Confrontation Clause only where either the person who made the hearsay statement was actually testifying at the trial and subject to cross-examination, or the declarant is not available, cannot be produced at trial, and there was a prior opportunity to cross-examine that witness, maybe a preliminary hearing, maybe a previous trial if the case was being retried after being reversed on appeal and something happened to the witness that they were no longer available at the time of the second trial. If the defendant had an opportunity to cross-examine, that was sufficient. Now, there was some confusion after Crawford. Some lower courts for a while thought that the Ohio v. Roberts reliability standards still applied if you had non-testimonial hearsay. But that was put to rest in a case called Wharton v. Boxing, another U.S. Supreme Court decision, which basically dealt with the non-retroactivity of Crawford to cases that were being reviewed on collateral review, post-conviction relief, habeas corpus. And what the court did say in that decision was that where non-testimonial hearsay is concerned, the confrontation clause does not even implicate. Not an issue, not something anyone needs to worry about, except that, of course, states have their hearsay rules, and you still have to satisfy those. And that kind of makes sense in a way because most hearsay exceptions are based on some notion that those kinds of statements, those particular statements, are basically reliable. That's why they're exceptions to the hearsay rule. And then what's probably one of the least helpful statements in the history of the United States Supreme Court jurisprudence, they stated, "We leave for another day any effort to spell out a comprehensive definition of testimony." And that is from the Supreme Court's Crawford majority decision. It has obviously this lack of any comprehensive definition is what has created a lot of the law that has followed, as courts try to sort out whether something is considered testimonial under Crawford or not, and therefore subject to confrontation. The next significant case on confrontation was a domestic violence case. It was actually two cases that were consolidated, Davis versus Washington and Hammond versus Indiana, generally cited as Davis versus Washington, but they were decided in the same opinion. And what we had here were two, in some ways similar, in some ways different, domestic violence cases. In Davis, the victim called 911 during the assault. She identified the defendant by name, said her husband was attacking her or her boyfriend as a dead witch. And she described the assault during the call. You could hear the defendant in the background yelling at her, and he fled at some point during the call. Now, when the case went to trial, the victim did not testify at the trial, but the 911 tape describing the assault, identifying the defendant, was admitted at trial. The defendant was convicted, and at that point, the state court said, okay, it was not intended to provide a statement for court purposes. The victim was reaching out for help, and the U.S. Supreme Court agreed and said that the 911 call was non-testimonial because the purpose of the call and the statements made by the victim and the questions by the operator were to meet an ongoing emergency. In contrast, Hammon versus Indiana was also a DV case, also a relatively minor one. The police responded to the scene after it was over. The parties were separated. The husband was in one room, the wife's in the other room. They were being questioned separately by the police. The victim tells the officers what happened. Again, the victim did not testify at trial, but the officers were called to testify to the victim's statements, which were admissible as excited utterances, I believe. And the state court said yes, if she was making these statements to meet this ongoing emergency, the officers were questioning them to find out what was happening. But what the court said was that the emergency had ended at that point, and that the questioning at that point was really to find out what happened for purposes of possibly later prosecution. So what we take out of that case is that a statement to law enforcement as a result of questioning is going to be considered non-testimonial if the objective circumstances, which means not what the parties' subjective personal purposes were, but if the objective circumstances show that the primary purpose of the questioning and response is to enable the police to meet an ongoing emergency, then it's going to be non-testimonial. On the other hand, if such a statement is made under objective circumstances showing that the primary purpose is to establish or prove past events potentially relevant to a later criminal trial, then it's going to be considered testimonial, and you have to satisfy the Crawford requirements. Michigan v. Bryant was the most recent case with not involving forensic evidence anyway before the U.S. Supreme Court, 2011. Police responded to a radio dispatch of a man who was shot. They find the victim on the ground with a gunshot to his abdomen, in a lot of pain, having difficulty talking, and the police asked, what happened? Who shot you? Where did this happen? And the victim is able to tell the police in his pain and agony who shot him and where it happened, which was, I believe, at the defendant's home. And the victim died at the hospital within hours, within just a matter of hours. And as a result of the analysis that the Supreme Court undertook in this case, the court, first of all, reaffirmed the primary purpose test out of Davis and looked at, stated that an objective evaluation of the circumstances to determine the primary purpose will include both the intention of and actions of the questioner as well as the person giving the statement. They also clarified that the existence of an ongoing emergency is among the most important factors, but not the only factor. And just as an aside, nobody seems to know that I've ever talked to why the issue of dying declaration was ever raised in the Bryant case, because most scholars consider that dying declarations are generally an exception to Crawford. I believe there's some language in cases that suggest that. The courts never met that issue squarely in any of its cases, but it was recognized as an exception to confrontation at the time of the founding. So most people believe that dying declarations would always come in. Apparently it was not raised that way, or the issue was not framed that way in Bryant, so the court never addressed that. So At this point in case law, between Crawford and Bryant, what do we know about testimonial and non-testimonial statements, at least in terms of non-forensic case? What kinds of statements are we talking about? First of all, Crawford, despite the fact that it did not give us a comprehensive definition, it did say a few things about what's considered testimony. For one thing, they identify testimonial statements as generally being a solemn declaration or affirmation made for the purpose of establishing or proving some fact. An accuser who is made a formal statement to a government agent can be contrasted with someone who's having a casual conversation with a neighbor or a friend or an acquaintance. If you're a victim and you're talking to your neighbor about how your husband beat you or hit you last night, you're not generally thinking that that is going to be for posterity to be presented in court. Statements that are directed at government agents that a reasonably objective person should know would be available for use at a later trial. On the theory that most people, when they're talking to the police, they're at least thinking this could wind up in court at some point, assuming that the emergency is over. This slide right here is actually taken from a document that's available at the AEquitas website library. It's called the Prosecutor's Resource on Crawford and its Progeny. We have a number of footnotes here. I'm not going to go through all the different cases that address these specific kinds of statements that are considered testimonial or non-testimonial. But these are the categories or the kinds of statements that have been addressed by the court and are fairly non-controversial at this point, pretty well settled. Testimonial includes ex parte in court testimony, testimony at a preliminary hearing, testimony before a grand jury, prior testimony at a former trial, statements taken by police officers in the course of their investigation, affidavits, including scientific reports and certificates, depositions, confessions by co-defendants, custodial examinations by police officers questioning suspects, pretrial statements that declarants could reasonably expect to be used prosecutorially, extrajudicial statements that are contained in formalized testimonial materials, certification of the non-existence of official records. And that is different from another case, actually. Non-testimonial includes informal statements, the 911 calls or statements to police while an emergency is in progress, where the primary purpose is meeting that emergency. Statements made and prepared without the reasonable contemplation of their use in a criminal trial. Ordinary business records generally are considered non-testimonial unless they were prepared specifically for the purpose of litigation. Tape recording of a conversation between an informant who's wearing a wire and a non-testifying accomplice, because the the accomplice who is making the statement isn't aware that he's talking to a police agent. So that's also considered non-testimonial. And of course, we have the gray areas, and I love this graphic that Charlie found for me. There are several areas that are highly fact-sensitive, and whether a statement is testimonial or not is not clear-cut. They're often highly fact-sensitive. They also differ from one jurisdiction to another, and the Supreme Court, the U.S. Supreme Court, has not definitively said how those are to be judged. Some courts will actually analyze them and sort of redact the portion that's considered testimonial and let the non-testimonial portion in. Other courts will look at it as a whole. These include such things as statements to state or stain examiners, sexual assault forensic examiners or sexual assault nurse examiners, statements to child protective services personnel, statements that are made to advocates, and that may depend on whether they're attached to the prosecutor or law enforcement or community advocates, statements that are partially for the purpose of creating evidence and partially for some other purpose, such as medical or safety. So, and the thing to remember is the Crawford, The Crawford does not apply in certain circumstances. It never applies if the witness is testifying in court and subject to cross-examination. Never is applying in civil proceedings, such as getting a restraining order, child support, that sort of thing. Does not apply in sentencing, at least in the non-capital sentencing context. There are some cases that held that in the penalty phase of a capital trial, it does apply. It does not apply to probation or parole revocation hearings. It does not apply if the hearsay statements are non-testimonial under Crawford. It does not apply if the hearsay statements are offered by the defendant himself, because only the defendant has the right of confrontation. And if he's offering a statement, then he's already waiving any right to cross-examine that person. Does not apply, generally speaking, to dying declarations. Does not apply to business records not prepared for litigation. So what you need to keep in mind also is if the statement is not testimonial, then Crawford does not apply, but state hearsay rules do apply, and it must fall within an exception, or you may lose on those grounds, even if you don't lose on the confrontation. This is another very nice graphic, which we have to, and we have given credit to Jessica Smith, who is a professor at the University of North Carolina School of Government. This is from one of her articles. She has several excellent articles on confrontation. And it's sort of a logic flow chart that you can go through to analyze, at least in the non-threatening context, whether something is going to have a confrontation problem or not, just to help you decide what is going to be admissible and what is not going to be admissible. When you're talking about whether the evidence is hearsay offered against the defendant, that's excluding such things as statements that are not being offered for the truth of the matter, so they're not hearsay. Under the one that's footnoted D, this Crawford exception line, exceptions include such things as dying declarations or statements that come in under forfeiture by wrongdoing, which is another specific exception to confrontation. Now, E, they talk about whether confrontation clause rights have been waived by the defense, waiver includes notice to demand provisions, which we'll talk about in a minute. That's where the defendant has to give notice of his desire to have an expert or a witness specifically testify in court as opposed to having a report come in. Also applies stipulations or situations where the defendant has by his own testimony or his own evidence opened the door to evidence offered by the state. So that was our quick review, and this is, we're getting now into the part of the presentation that you all paid the big money to hear. Crawford in the context of, Crawford in the context of forensic evidence. And we're going to talk about 3 U.S. Supreme Court cases first. Question being, how does Crawford apply in the context of forensic evidence? And you can really sum that up in about 3 words, which would be not very well. There are many contexts in which an out-of-court statement by non-testifying forensic evidence will somehow or other find their way into a criminal trial, either through a report, through sub-reports that are relied on by other experts. There are a number of different ways that can happen. Now, these are real practical problems that we face as prosecutors. Think about the volume of samples that a typical technician or analyst working in a state police lab, test or FBI lab, test day in and day out. Think about how many different courtrooms they might have to be in, that they might be called to testify in, particularly when defendants know that they can insist on having the analyst testify. Think about if any of you have ever tried DNA cases. You know that the DNA testing process, analysis process, involves a number of different steps in the lab, not all of which are done by the same technician. You don't have the same person signing for the evidence that's being submitted, taking it over, doing it step by step by step on the same sample, and then writing a report. That's not how it works in the lab. We have a number of technicians who do maybe their same little piece of it, like an assembly line, over and over and over again on different samples. You have, think about the fact, too, that some of these numerous little steps might be performed by independent labs. Sometimes local labs don't have the capacity. They can't get the analysis done quickly enough. States and counties and prosecutors' offices and police departments contract with outside agencies sometimes to do their testing. And they may be located out of state. Most of us do not work in prosecutors' offices that have unlimited budgets. In a typical criminal case that is not involving a high-profile crime, most prosecutors are not going to be able to go to their section chief or their office administrator to get approval to fly in all the analysts who touch some aspect of the testing on your case. You might also be up against judges who are pushing a case to go to trial, in spite of the fact that you may not have your particular expert available. Someone might be out on maternity leave. There are a number, or might be tied up in court in another courtroom. There's also the issue of cold cases, which is coming up more and more as we're able to reach further into the past and solve some of these through scientific evidence. The original medical examiner who performed the autopsy may now be retired and living overseas. They might be deceased, and maybe the body has decomposed to the point where the gunpowder stippling or the angle of the knife or gunshot wound can no longer be observed by a new analyst. So one way or another, statements that are made out of court may have to be relied on in some fashion to get those before a jury today. So these are seriously practical questions. So we're going to take a look at those three U.S. Supreme Court cases involving forensic evidence where the Crawford issues have arisen, and then we'll take a look at the lower court's treatment of those decisions and help you come up with some strategies that will help you protect your hard-won conviction from being reversed on appeal for confrontation issues involving forensic evidence. And when we talk about these, it helps to have a scorecard to count justices, because you will see with these cases, once we leave the realm of ordinary fact witnesses and get into forensic witness testimony, there is a definite split in the court. And certain of the justices would treat forensic evidence much differently than they do the testimony that comes from ordinary fact witnesses. And divination skills, this is a quote that I love. It's from a California case, Court of Appeals case from just this year. And what they said was that trying to predict how the Supreme Court is going to decide the next forensic evidence case can be what they call an exercise in tapiomancy. So that's your word for the day that you're learning. It means divination by reading tea leaves. And it certainly does describe what's going on with these cases. This whole area of the law is in flux. Anything you hear about what lower courts have done in the wake of these U.S. Supreme Court decisions may change as soon as the next U.S. Supreme Court case comes down the pipe. So with that caveat, we will go on to Melendez-DIAZ versus Massachusetts, which is a 2009 decision. Melendez-DIAZ was a drug case. The defendant was charged with distribution of over 14 grams of cocaine. The state introduced, what was normal practice at the time, a certified lab report indicating that the substance that they seized from the defendant tested positive for cocaine and that it was a certain weight, over 14 grams. And that certified lab report was sworn to by the analyst. There was like one of those little stamps that say, I certify that this is a truthful statement of the results of my testing, blah, blah, blah. So the state courts, because that was normal practice, the state courts held that the admission of a certified lab report was not testimonial and therefore not subject to confrontation. Now, here is where I start listing which justices come out which way. The majority opinion in Melendez-DIAZ was written again by Justice Scalia. This is confrontation is one of his topics he's passionate about. And he had 4 of the other justices on his side joining the same majority opinion. And what he said was that certified lab reports are the equivalent of affidavit. After all, you've got that whole sworn and certified too, usually stamped on the report and signed by the analyst. And they therefore fall within that core class of testimonial statements, and they're proffered and are subject to the right of confrontation. The person who wrote the report, that's what they do for a living in state police labs. They intend them to be used at trial. That's why they are created. And the court determined that, therefore, the defendants have the right to cross-examine the analyst. The analyst who performed the test. And the opinion goes on to reject several of the arguments that were made by the defense or made by the state in that case. They rejected the argument that lab reports should be treated differently because they're not accusatory statements. After all, they're just kind of neutral. Usually they aren't being intended to be used specifically to convict John Doe. The analyst performing the test does not even know who the person is that was caught in possession of the drug. The court said instead, if the evidence is used against the defendant, that's sufficient to make it testimonial. The court also rejected the argument that scientific evidence is somehow different because it's neutral or objective. They reiterated the Crawford principle that the reliability of the test, the statements made in the report, can only be tested through cross-examination, not because it's presumed to be reliable. The court also rejected another Crawford rationale for treating this differently as a business record. They said that when evidence is documented for the purpose of litigation, because no police officer sends something out to be analyzed just because it's intended to be evidence in a criminal case, then confrontation is required. The court said that business records only qualify as an exception to confrontation when they were not created for that purpose. They also made sort of an interesting distinction in some dicta in the opinion that a certification authenticating an official record is considered an ordinary business record and therefore is not testimony because the government offices are required to keep track of these documents for all purposes. So the fact that they are certifying that it's authentic does not mean that it was created for purposes of litigation. On the other hand, they said that certification of the absence of an official record, for instance, in some cases where, in some states where someone is, there's a rebuttable presumption that someone who does not have a evidence of a firearms permit, that there is a presumption that it's not there, and we put in some certificate or affidavit of the records custodian saying that I don't have a record of this person having a gun permit. That, if that's part of the evidence to establish his guilt, that is considered to be testimonial evidence, so you would have to call that custodian. They also rejected the argument that a defendant's rights are satisfied by his ability to subpoena the analyst. They did, however, approve the use of notice and demand statutes. And many states actually added or enhanced or refined their laws, their statutes on notice and demand. And many states adopted statutes now that say, unless the defendant gives notice within X number of days before trial, the state is entitled to rely on the certified lab result. So it sort of shifts the burden of coming forward to say, you know, I'm going to object to this to a little earlier point in the proceeding. And if the court says if the defendant does not make that timely objection, that his right of confrontation could be deemed to be waived. Now, there's also one interesting footnote here in Melendez-DIAZ, which also gives you a little bit of a clue about how you can proceed in these cases. Footnote 1 states that not all witnesses involved in the chain of custody, the proper functioning of equipment necessarily needs to be called. Chain of custody really goes to weight rather than admissibility of the evidence. And records concerning maintenance of equipment might be conventional non-testimonial business records because the state has to maintain the equipment no matter what. Now, Justice Thomas, who joined the majority opinion, and this is significant, as we'll see shortly, a little further down when we talk about the Williams decision, he wrote a one-paragraph concurrence in which he emphasized that formality should be the basis for the right of confrontation. That's the formality of a statement that makes the testimonial. It's the formality of the statement that gives the defendant the right to cross-examine. The dissent, and pay attention to this dissenting group, because this same group of 4 justices are together on the other cases that followed. Justice Kennedy, Roberts, Chief Justice Roberts, Justice Alito, and Justice Breyer. Their dissent noted, first of all, that forensic reports have been admissible without analyst testimony for at least 90 years, ever since scientific evidence started being used. And they said that the majority had swept away almost a century of jurisprudence based on Crawford and Davis, which were cases that had nothing to do with scientific evidence, but rather involved typical fact witness. The dissent also went on, and this is a quote, because the court is driven by nothing more than a wooden application of the Crawford and Davis definition of testimonial, divorced from any guidance from history, precedent, or common sense, there is no way to predict future applications of state holding. Surely part of the justification for the court's formalism must lie in its predictability. There is nothing predictable here, however, other than the uncertainty and disruption that must now ensue. And those were very, very prescient statements. So the next case was BULLCOMING versus New Mexico. BULLCOMING was a DWI case, and by the way, that was from 2011, BULLCOMING. The state introduced a certified lab report that the defendant let out alcohol content was above the threshold. That happened in part because the trial preceded the decision in Melendez-DIAZ. The analyst who performed the test and certified the result was unavailable for trial, and instead the state called a substitute analyst who was familiar with the lab protocols but not personally involved in or observing the test of the defendant's blood sample. The state trial court admitted the report as a business record, and a substitute witness who was from the same lab testified to what the procedures were used and how the test would have been performed, how the machine worked, and so forth. The state Supreme Court affirmed the conviction, although the lab report was, in fact, the report itself was testimonial under Melendez-DIAZ, but that the analyst who performed the test was really a mere scrivener of machine results, so that another analyst familiar with procedures could look at that report and form his own opinion and provide that opinion to the jury, and cross-examination of that witness was sufficient for confrontation purposes. The majority opinion, again, was Scalia in the majority. He didn't write it, Justice Ginsburg did, and Justice Thomas joined it. Stated that the lab report was in fact testimonial because it was sufficiently formal, because it had been certified in spite of the fact that it wasn't under oath, and because the report was prepared for the purpose of the police investigation. And they stated that the confrontation clause requires that the defendant have the opportunity to cross-examine the actual analyst who did the test, who was the original declarant, not a substitute witness who had no personal involvement in the test. That's worth noting, too, that in this case, the analyst who actually performed the test was on unpaid leave, which the Supreme Court took as highly suspicious. They were saying, he could have been suspended for dishonesty, he might have been incompetent. And I was giving a training recently in New Mexico, which is the state that BULLCOMING comes from, and was informed when I asked around that, in fact, the analyst was on some kind of family leave, had nothing to do with his performance. But that's the kind of thing you may not want to leave the court to speculate about in your case. If your witness is not available, make sure you explain why. BULLCOMING, there was a concurrence by Justice Sotomayor, who noted that there were certain issues that were not presented by that case, including testing the Teresa dual purpose, both to create evidence for trial and maybe some other purpose, like the medical examination. Did not present a case where there was testimony by a supervisor who had at least some connection by virtue of being a supervisor to the test, nor did it present the situation of testimony of an expert whose opinion relied on a report that was not actually admitted into evidence, which is the situation that came up in Williams, ultimately. The dissent, again, it's the same dissenting group of justices who dissented in MELENDEZ-DIAZ, and again raising similar practical concerns. How can the court, how can prosecutors know which of many of these witnesses in some kinds of testing situation has to be called? And so we might even call these justices the practical four. They're the ones looking at it from a very practical point of view. And here is basically where everything kind of goes to hell in a handbag. Williams versus Illinois, 2011 decision. This case involved a sexual assault. The victim had been kidnapped, raped, and robbed by a stranger who she got a good look at, but they were not able to identify who the person was. They performed a rape kit. They sent the vaginal swabs from the rape kit to an independent lab called Cellmark that was helping out the state. They were under contract with the state. Cellmark was able to separate out a male DNA profile, which they returned to the state of Illinois, and it was put into the state's DNA bank. They came up with a possible match to the defendant, Williams, who had been since arrested on another charge, so his DNA was in the bank. And when they put him into a lineup, the victim was able to identify him as the person who had attacked. There was a bench trial, non-jury. The state's witnesses included the technician from the state lab who developed the defendant's known DNA profile, which they did once they had come up with a potential match. They also presented evidence in the form of testimony by the analyst who did the comparison between this known profile and the unknown male profile, initially unknown male profile, that Cellmark separated out from the victim's vaginal swab, and testified to her opinion that they matched. The Cellmark report itself was not admitted into evidence, and no witness from Cellmark testified. No supervisor, no peer reviewer, nobody at all. So the state court, Supreme Court, rejected the defendant's confrontation claim based on the fact that, or the argument that the Cellmark report was not admitted for its truth, that it was only considered by the testifying expert as basis for her opinion. The U.S. Supreme Court, in a very kind of troubling decision, troubling for all of us who have to try to follow it, troubling to the state courts who have to try to follow it, there was a four-justice plurality opinion that gave specific reasons why they believed that the evidence did not violate the confrontation clause. Justice Thomas joined those four as the fifth vote to affirm the conviction, but he did it for an entirely different reason, which makes everything even more confusing than it already was. So the fact that the justices split their votes that way means that Williams is of very limited or no precedential value, except as sort of an intellectual exercise to maybe try to predict how the U.S. Supreme Court might decide the next case. But meantime, the state courts and prosecutors are trying to make sense of it. In the plurality opinion, which is the same four that were in the dissent, remember, on the other two cases, they concluded there was no violation of the defendant's right of confrontation because the Selmark result was not submitted for the truth of the matter, but rather as the basis of the testifying expert's opinion, which is exactly what the state Supreme Court said. And they said, even though a jury might have trouble understanding the difference and ignoring the fact that it's not being offered as substantive evidence, they said this was a bench trial and the judge wasn't going to even possibly consider it for the wrong purpose. They also had another reason why it didn't violate the confrontation clause, which was that it was non-testimonial because no suspect had been identified. They sort of analogized it to an ongoing emergency situation because they had no suspect. A dangerous rapist was at large, and that's why this test was performed. They weren't trying to prove that this particular defendant was the rapist in the case. So the concurring opinion, and it's interesting to read the various opinions in Williams, but only to hear how kind of sniping the justices are back and forth with each other. Justice Thomas, in his concurring opinion, says, well, I agree that the defendant's right of confrontation was not violated, but the majority is completely out in left field. They're wrong. It was not testimonial only because it lacked the requisite formality. The test was not certified or sworn to, and therefore it was non-testimonial. No other justice looks at it that way. He is the Lone Ranger out there, but because he has become the swing vote on these cases, formality is assuming an importance among the lower courts now that are interpreting this, that probably Justice Thomas is the only one that would attach that much importance to it. The dissenting opinion is the remaining four justices. They conclude that the defendant's right of confrontation was violated. And this is a rare instance where you really do have to pay attention to the dissenting opinion. Because had that statement simply been sworn and certified, which many forensic tests are, you would have these justices in the majority. So depending, again, on whether something turns out to be formal or not, you have these four justices against the four who wrote the plurality opinion in this case. They concluded that this was exactly like MELENDEZ-DIAZ and BULLCOMING, or close enough to require the live testimony of the Selmark analyst. They rejected the plurality analysis and conclusions, and actually were rather derisive about it. They stated that if the state lab analyst had testified in response to a hypothetical question, like, if you assume, for the sake of argument, that this particular sample was, in fact, the male portion extracted from the victim's vaginal swab, do you have an opinion? They said if the question had been asked that way, it might have been okay because the state might have been able to prove by circumstantial evidence the chain of custody that it was what it purported to be, and that there might have been circumstantial evidence of the reliability of the test. because, after all, the victim also selected this person from the lineup. But, in fact, that was not what happened here. Now, there's also an interesting footnote that we want to pay attention to in this defense, which was written by Justice Kagan. She said, none of our cases, including this one, have answered or presented the question of how many analysts must testify by give a report. That may suggest that in most cases, a lead analyst is readily identifiable. The problem in the cases, again, including this one, is that no analyst can fully testify. Again, that gives you a clue what may be required in order for a case to pass muster in the next round of cases. So this slide really is just a recap of the positions, it's sort of a cheat sheet that shows you how the decision itself to save you from going back and forth between the opinions. But the bottom line here, the result, is that we have a very fact-bound decision, and we have a plurality opinion. So the reasoning in that opinion may never be applicable to another case unless you happen to have the case that is also, quote, unquote, according to Justice Thomas, informal. There is actually a case called Marks versus the United States that says that when a fragmented court decides a case and no single rationale explaining the results enjoys the assent or agreement of 5 justices, the holding of the court may be viewed as that position taken by those members who concurred in the judgment on the narrowest ground. If you boil that down, the problem here is that there is no overlap between Justice Thomas's position and the majority or the plurality opinion in this case. So really, what do we do with it? And that's what the courts are struggling to do with it now. And this is what we just talked about. It's only going to, the basis for the expert opinion, or where no suspect has been identified, that's only going to fly under Williams if it also lacks formality or solemnity that Justice Thomas required. Now, Justice Kennedy's prediction in his dissenting opinion in Melendez-DIAZ has come true. And that quote was, there is nothing predictable here other than the uncertainty and disruption that must now ensue. So if you are sitting there at your computer, assuming you are still alert and awake, and are saying to yourself, I just can't figure this stuff out, I must be missing something, trust me, it's not you. You can be reassured on that count. The courts that have decided forensic cases involving confrontation issues after the Williams decision, they certainly have to talk about Williams because it's the most recent case, but the various state courts and lower federal courts have taken very different views. Some are being very, very cautious with it and not letting very much forensic evidence in. They are basically taking the position adopted by the dissent, and in some cases even keeping out some evidence that a majority of the courts in Williams would probably allow in. Others have focused on Justice Thomas as a swing vote involving formality and have really kind of allowed a lot of evidence in that maybe a majority of the Williams court would not have allowed. California has probably had the most cases that they have addressed this issue, and they take a very liberal approach to it. In fact, they've decided 3 forensic Crawford cases in one day. I haven't talked about one of them because when they wound up deciding harmless error, it didn't really address it. But People versus Lopez involved a lab report where the analyst who performed the test put his initials on it that wasn't sworn or certified. That person was not called to testify. A different analyst from the same lab testified to his or her own interpretation of the results. And they said that was okay because the lab report initials and the underlying data that was contained in that report was not sufficiently formal. And the California Supreme Court concluded that the 2 essential elements for a report to be testimonial under Williams is at least some degree of formality, and that the statement or report pertains in some fashion to criminal prosecution. So that's the way California has boiled it down. Whether a majority of the U.S. Supreme Court would agree with that is up for debate. Some of the additional California cases, People versus Dungo, there have been a couple of autopsy cases. Dungo involved the testimony of a pathologist who was not the one who performed the autopsy. And the court reasoned that that was admissible and okay and did not violate the confrontation clause because autopsies are not performed just for purposes of prosecution. There are a number of reasons why autopsies may be performed, and the fact that this one may have been done for that reason is not enough to take it out of that realm. The court also held that the objective observations contained in an autopsy report are not formal. People versus Edwards was similar. People versus Holmes held that it was okay for a supervisor to testify regarding a DNA test that they did not personally perform. And People versus Garvey, which, if you recall, was the Papiamency, the tea leaf reading case opinion, held that it was all right for a lab director to testify regarding DNA tests that he had not personally performed, and also held that the actual reports, provided that they weren't actually certified, could be admitted as well. Illinois also takes a very liberal view relative to some of the other states in terms of Williams-type cases. They also concluded that a reviewing pathologist could testify regarding an autopsy that was performed by a different pathologist, as long as she was testifying based on her own conclusion. They also said that it was okay for the autopsy report itself to be admitted, even because it had neither been signed nor certified. Also made the same observation in California, that there are many reasons why autopsies can be performed, and that they are not necessarily intended to target the particular subject or suspect, but rather to show how the victim died. Maryland has a case called Durr versus State, and Durr is somewhat interesting because the Maryland Supreme Court actually changed its position. It had reversed a conviction on confrontation grounds. When it went up to the U.S. Supreme Court, Williams had been decided. The court sent it back for reconsideration in light of Williams, and the Maryland Supreme Court actually changed its position and said that there was no confrontation violation. There were a number of different tests that were done. This was if I remember correctly, I believe the suspect was unknown for quite some period of time. There were a total of 4 different DNA samples or 4 testing sessions that were performed in 1985, 2002, 2004, 2006. At trial, the state only called the analyst who supervised the 2004 and 2006 analysis, but didn't personally participate or observe. But all of the test results came in through that analyst testimony, and the reports themselves were also admitted. And again, the Maryland court focused on the formality issue and said that those test results were not sufficiently formal to be testimonial. North Carolina said it was okay for a peer reviewer to testify to the results of drug tests she did not personally perform. The testimony was based on her review of lab notes by the testing analyst on machine data that was contained in the file and machine data that was actually still stored in the machine itself. The report of the testing analyst, the original report that was written, was never introduced as evidence. But anyway, North Carolina is on board with that. State versus Deadbiller is almost identical to Williams, but Deadbiller had a jury trial rather than a bench trial, as Williams did. And they applied Williams in a fairly straightforward way and held that there was no confrontation violation for the state lab analyst testified and moved the analyst from an independent contract lab that actually did the testing itself. Now, on the other side of it, these courts that we're going to talk about now have taken a much more conservative, and you're going to have to look at what your own state is doing with these cases, if there have been any decisions. And you also have to keep in mind that even if you live in a quote-unquote liberal state that's allowing a lot of this evidence in, it may not be the same way as after the next U.S. Supreme Court decision comes in. Young versus United States is a D.C. Court of Appeals case. They said the testimony of an analyst who was not involved in the testing at all, but was actually from the same lab, about a DNA comparison from the victim swab to a defendant's known sample violated the confrontation clause. And they concluded, as did the dissenting justices in Williams, that the test results, even though the reports were not admitted, had been offered for their truth. Also worth noting that in this case there was no limiting instruction telling the jury about any limited purpose, so that might have made a difference. We don't know. They stated that at least the test of the sample that they took from the suspect after he became a suspect was for purposes of prosecution, but therefore it was testimony. This case, again, Delaware is similar. There's a testimony of a certifying analyst who prepared a report on drugs that were found in the defendant's blood. It was based on batch results of machine testing that had been done by another technician at the same lab. And that they concluded that had violated the confrontation clause. They said that the defendant had the right to perform the technician who actually performed the machine testing. So even though the opinion was based on what it mattered to raw machine data, they said we still had to call the analyst who actually ran the machine. This is an interesting case simply because it, for once, doesn't involve DNA or physical forensic evidence. It involves technical evidence. It was a child pornography case involving the internet. And the prosecution introduced user activity reports to show who was using a particular IP address. Those had been maintained by the ISP as part of their ordinary course of business. They keep track of who's online, who's not online, who logs in. But the state also introduced summary reports prepared by the ISP and by the National Center for Missing and Exploited Children that had been compiled. What they went through is they just looked at that and put together a list of what amounted to significant data that indicated that this particular defendant was the one involved in the child pornography. And interestingly, the First Circuit held that the reports that were maintained by the ISPs as part of their ordinary course of business were non-testimonial, but that the summary of those reports, which added nothing new, there was nothing manipulated or changed. In fact, the court referred to them as obvious conclusions that were drawn from the reports maintained by the ISP. It would be like taking notes directly from a book. That the summaries were testimonial, and therefore you had to call the person who only did the mechanical task of pulling out the relevant data. Now that goes much further than probably even the dissenting justices in Williams would go, and I'm not quite sure. I think that's taking it, the concept of testimonial really to the extreme. New Mexico, having been burned, I guess, on the BULLCOMING case, they are being extremely cautious. State versus Navarrete involved an autopsy. The testimony of the pathologist who was not the one who either performed it or observed the autopsy, who offered his own conclusions about subjective findings that were made by the original examining pathologist regarding twist and stippling around a gunshot wound violates the defendant's right of confrontation. The report itself was not admitted. And the New Mexico Supreme Court concluded that autopsies are indeed intended to generate evidence for prosecution. So the statements of the examining pathologist are testimonial. They stated, however, that the testifying pathologist's independent conclusion based on objective data, for example, looking at photographs that were taken during the autopsy and drawing a conclusion about the angle of a wound there, something that you could conclude just by looking at the photograph would be admissible without violating the confrontation clause. But that more subjective determination requires the cross-examination of the pathologist who actually performed the autopsy. Now, it's very clear to see when you're talking about a case like this how problematic that could be if this was a 20-year-old cold case and that was your only evidence that you needed in order to prove the case. West Virginia, State versus Kennedy, very similar to Navarrete. They said that autopsy reports are under all circumstances testimonial. And the testifying pathologist's independent conclusions based on objective data, such as the photograph, as in Navarrete, would be admissible without violating the confrontation clause. However, a couple of places, the testifying pathologist stated that he or she agreed with the report prepared by the original examining pathologist, and the court said that was a problem, that was a violation of the confrontation clause. So you have to be careful with statements like expressing agreement. So that is kind of the unfortunate state of the law that we find ourselves in right now. Imagine that you're getting your case ready for trial and you have to decide what witnesses you need to call. Let's say it's a DNA case. Let's say you have maybe a couple of rape victims. Maybe you have a couple of suspects who had to be eliminated to a DNA case. That could be numerous analysts who have at some point touched that evidence. Maybe some of those DNA experts or analysts or technicians are located out of state. Are you going to go to your boss or your office administrator and say, I need to fly in 10 DNA experts because at some point they participated in performing this DNA test that the next technician had to rely on to form their opinion? I don't think any of us wants to be in that situation. It doesn't make you real popular with your bosses, and it's not practical, and they're going to say no anyway. Or let's say you're trying a cold case where the suspect has just been identified after many, many years, and you can't bring in the original expert. They can't be located, they're living overseas, they're deceased. You have to do what you can to protect your conviction from reversal on confrontation grounds. So, in most cases, your bosses, except in the highest profile cases, is going to suggest that you keep down to the bare minimum the expense, the trouble, the difficulty, the trial resources that will be absorbed or will be used up by calling all these numerous witnesses. So you have to sit down and figure out who you're going to call to testify. Who is going on that witness list? Who are the witnesses you absolutely can't live without? How do you decide? And what are the strategies you can follow to try to hedge your bets as best you can? And that's what we're going to talk about here. First of all, the first thing you should do is really find out whether your state is one that has addressed this issue of evidence, forensic evidence, in the context of confrontation. And find out what stance they take. Just keep in mind, though, that it may not be the same way after the next U.S. Supreme Court case. If it's difficult. You just have to decide what level of risk is tolerable, and for everybody and for every case and for every judge, you know your judge is the best. You'll just have to decide what makes the most sense. The safest option, this is the, if you could possibly call every technician and analyst that was involved in the testing, that is the surefire guarantee that at the very least, whatever else goes wrong with your case, it's not going to get reversed on confrontation grounds, at least so far as the testifying analyst goes. If you have all those witnesses testify, you can have this witness relying on the statement by that witness, blah, 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 as long as you have all those people testify. That's not practical in any situation. In some situations where you only have one or two technicians, it might. It's worth considering. It's your safe haven, the safest thing you can possibly do. The next reasonable step that you might take, based on that footnote in Williams in the dissenting opinion, I believe it was footnote 4 in the dissent, is to call the lead analyst for each test. And possibly, if it's complicated test with a number of steps, possibly call any of the other technicians who are involved in any of the steps that were particularly critical. That's one fairly safe thing that you can probably do based on what we have seen so far in the Williams decision. You can also call only the lead analyst. Again, that's a little more risky again. Each time you go down and choose one of these, there's a little more risk involved in having your conviction stand up if the defendant raises the appropriate objection and if the Supreme Court changes its stance or if your Supreme Court views it in a certain fashion. Here's an option that a lot of people don't even think of. What if you were to try your case without using that forensic evidence? Could you prove it? Not every bit of evidence in the case is usually crucial to proving your case. In some cases, the real issue is a consent issue. It's not really even going to be a whodunit. The only reason you might be putting in the DNA is to counter the CSI effect, where the jurors expect to hear all this forensic evidence. But really, do you really need it? Might it not be better for your case and for your ability to have it stand up on appeal when there's a confrontation challenge to just forego that evidence and try the case based on the other evidence you have, on the victim's testimony, on other kinds of trace evidence that might be involved, circumstantial evidence? Think about it. Everything that is in your file does not have to be presented to the jury. Be careful if you do that, though, not to let the defense use this against you. I would suggest if you have something like a DNA test result that implicates the defendant, you seek file a motion in limine to prevent the defense from trying to argue information that your case is weak because no DNA evidence was presented. Because clearly there was DNA evidence that inculpated this client. You certainly shouldn't be able to argue your failure to put it in somehow exculpated. So don't let the defense use that unfairly against you to try to get a ruling from the court in advance so that they can't suggest either that you did a shoddy investigation or the state did a shoddy investigation because it was in fact tested, or to suggest that if the test came in, it would have somehow exculpated this client because, in fact, he knew that it did inculpate. So you want to just make sure that you dot that I and cross that T. If you have unavailable experts, do put on the record all pertinent reasons why any of them were not called, either expenses, can't locate the analyst, If they're on leave, find out why. Put those things on the record. You don't want the court to be doing what the Supreme Court did in BULLCOMING, which is speculate that you're somehow hiding a dishonest analyst by not calling them to testify at trial. And remember, if your state has notice and demand statutes, take advantage of that. That's still a valid consideration and a path you can follow. If the defendant has to object within a certain amount of time, give him or her notice of your intention to put this report in, and if the defendant does not object, then the objection is waived. If the lead analyst in a particular case is not available and you need to get that report in or the substance of the report in, see if you can possibly have the sample retested. Sometimes that will be possible, sometimes it won't be possible. You may even, and I've had this situation, get into an argument with people at the lab who don't understand why. Remember, you're the prosecutor, you're the lawyer, you know what needs to be presented. If it needs to be retested, insist on having it retested, if that is possible to do. Another avenue, see if the defense will stipulate to the results of the test. It may be that in a particular case, for instance, where the defense is consent on a sexual assault case, maybe the defendant doesn't really care that much about the DNA, and maybe will agree to stipulate to it in the interest of appearing cooperative in front of the jury. Look, I'm going to admit this, but here is my defense. And that way you'll be satisfying the jury's urge to hear about this DNA testing without having to go through a whole battle over it. See if you can call the analyst supervisor who personally observed the test. That's always preferable. If you have someone who can at least say, yeah, I was there, I observed, I didn't see anything that went wrong. If I had seen the person, make a mistake, I would have stopped them, I would have made them retest it, whatever the case may be. That's another option as well. And the kind of ironic thing with all this, the Supreme Court's concern about uncovering the dishonest or incompetent analysts, I would bet you that probably 99% of analysts do not remember the details of any one particular test that they perform. In 99 out of 100 cases, I would bet that's so. So that's sort of ironic, but they're still entitled, defendants still generally entitled to cross-examine. If your only option is calling an expert who was not personally involved in the testing, be careful to ask your question in hypothetical form. Read the opinion in the dissenting opinion in Williams versus Illinois and see how they describe how that question might have been okay, or that testimony might have been okay if the question had been asked in exactly the right way. Also, make sure that the judge instructs the jury properly. If you have a model, even if you don't have a model jury instruction on hypothetical questions and expert testimony, create them, write them, ask the judge to give it to the jury. It's one less avenue that the convicted defendant can use to escape that conviction on confrontation grounds later. Good jury instructions have saved many occasions. If you do that, then carefully prove the facts that underlie those hypothetical facts that you're asking your witness to base his or her opinion on. And do that using circumstantial evidence or whatever evidence you have, business records showing chain of custody, etc. Remember, those business records, as long as they're kept in the ordinary course of business, and generally police agencies routinely just keep track of their evidence that way. It's not for the purposes of that particular trial. That generally does come in as an ordinary business record. So the bottom line is, if you're not calling the lead analyst, It's somewhat risky, and you really have to ask yourself, how lucky do you feel? How much risk are you willing to tolerate on this particular case? So the question about what's coming next in these cases, as we've seen, the Supreme Court seems to be shifting away from the overwhelming majority that supported the original Crawford down to recognizing that this standard really isn't very workable in the forensic setting. We have an even split of the justices, 4-4, taking different positions on it, with Justice Thomas alone being the swing vote advocating formality in standards, which has really been pretty much rejected by all the other justices. And, of course, we've got these 20-year-old cold cases as the scientific ability or the ability of science to solve some of these cases gets better and better, and the tests get more and more sensitive. We're going to be getting more and more of these old cases where we may need to be getting in autopsy reports, ME reports from 20 years ago or longer. Those are going to present troubling challenges unless the court does something about it. We're going to have a lot of people who can simply wait out the experts and basically go free. For now, your safest course is to err on the side, if you have to make a decision, of assuming that the court will continue with the position taken by the defense in Williams. If you do that, then you're going to be safe. If you can't do that, then you have to do the best you can with some of the strategies, such as those that we've suggested here. And that comes to the end. If anyone has any questions, we've got a couple of minutes left here. I'd be glad to try to answer them, but hopefully you will take away from this some stuff that you can use, and it will be very interesting to see what comes down the pipe from the U.S. Supreme Court. Thank you very much for your attention.
Thank you, Terry. And here we have a slide that just talks about AEquitas' library page, some of the resources we have available, monographs, prosecution resources that Terry mentioned, some newsletters, there's strategies and brief and strategy newsletters, and one of those does address Williamsville, Illinois, forensic evidence. We also have a number of statutory compilations and case law summaries available and additional resources as well. So I just want to thank Terry and all of you in attendance for your participation and dedication to increasing victim safety and offender accountability in your communities and across the country. Please visit our website, AEquitasResources.org, where you can register for future webinars and training events and review the information here about AEquitas and more. And please, you'll receive a link to the SurveyMonkey evaluation of today's webinar, along with a copy of the PowerPoint presentation and Terry's full biography. So please respond to the follow-up email and fill out that survey. And if you're interested in daily credits, you can ask about those in response to that email. And do remember that AEquitas is a 24/7 technical assistance provider, and we're available to respond to questions, concerns, and training needs as they relate to prosecution of violence against women. So on behalf of AEquitas, thank you so much for participating in today's webinar. And we will stay on the line for a few more minutes if anyone does have any questions. Thank you.